The Anti-Terrorism Act is not an instrument of oppression. Neither is it a tool to suppress vibrance of our democracy. No, it is an embodiment of the state's policy to protect life, liberty, and property from terrorism, a commitment to peace in our day and future of our children. In the words of our President Rodrigo Roa Duterte, and I quote him, "For the law-abiding citizens of this country, I am addressing you with all sincerity. Huwag ho kayong matakot kung hindi ka terorista."
Isang mapag-alang araw po sa ating lahat mga kasangga. Talakayin natin ang mga usaping balita at mga isyu na nagaganap sa ating bansa at ito'y ating bigyan ng mga kuro-kuro, komento at opinyon. Ilahad natin ang tunay na pangyayari na dito lang natin mapapanood sa social media na dilingid sa ating kaalaman na ang bang mainstream media ay hindi nila ipinapahayag ang katotohanan. Mga kasangga, kung hindi ka pa nakakasunod sa aking channel, pakipindot ang subscribe at isama mo na rin ang notification bell button para updated ka sa lahat ng ating mga usapin. Kung nagustuhan mo, huwag mong kalimutan i-like at mag-komento ng iyong sariling opinion.
Under the United Nations Security Council Resolution number 1373 and the International Convention for the Suppression of the Financing of Terrorism. As a member of the United Nations, the Philippines should fulfill in good faith the obligations it assumed in accordance with the UN Charter and should agree to accept and carry out the decisions of the UNSC. Under UNSCR number 1373, member states such as the Philippines are mandated to prohibit their nationals from making funds, financial services, or economic resources available to those who commit terrorist acts. The latest mutual evaluation report of the FATF rated the Philippines as only compliant to UNSCR number 1373. The UNSC found Philippines' efforts in preventing terrorist financing as grossly deficient. Gray listing reduces investor and lending confidence. It may also result to limited access to banking and financial services. Millions of OFWs and their families will be severely affected by the higher cost of remittances, which reduce the amount of their support. Philippine banks will also increase loan interest to borrowers. With higher interest rates, the effect will trickle down to businesses of the country, which will have higher costs of operations. Clearly, gray listing would seriously affect the country's international trade, remittances, and humanitarian financial flows that support the country's economic growth and development. The Anti-Terrorism Act, most especially sections 25 and 36 thereof, serves as a lifeline to the continued strength of the Philippine financial system. If the country fails to adopt a legal framework compliant with our international obligations, gray listing is not a risk, but an inevitability. Petitions are formally defective. While we could have ended our presentation in the foregoing grounds for outright dismissal, we notice that the petitions are insufficient in form and substance. The legal procedure states, Section 3, dismissal due to fault of plaintiff. If for no justifiable cause, the plaintiff fails to comply with these rules or any order of the court, the complaint may be dismissed upon the motion of the defendant or upon the court's own motion. This dismissal shall have the effect of an adjudication upon the merits unless otherwise declared by the court. In Abogado versus DENR, this court ruled, and I quote, "As with the procedure in special civil actions for certiorari, prohibition, and mandamus, this procedure also requires that the petition should be sufficient in form and substance before a court can take further action. Failure to comply may be the basis for the petition's outright dismissal," unquote. All 37 petitions must be dismissed due to formal violations and non-compliance with the resolution of this court. 1. The following petitions lack verification and certification of non-forum shopping or detached defective ones. Hindi Abendan of the Center for Youth Participation and Development Initiatives et al., Dr. Ramon Guillermo et al., Harun Al-Rashid Alonto Lukman Jr. et al., Lagman et al., and Lawrence A. Yerbo. 2. The following petitions fail to state the required attestations found in Section 4, Rule 7 of the said rules. Center of Trade Human Rights, San Lakas, Federation of Free Workers et al., Alagmar Latif, Concerned Online Citizens et al., and Anak Mindanao Party List. 3. The following petitions has not, to this day, submitted special power of attorney to allow their counsel to represent their interest in this case. Longid et al. Number 4. The following petitions failed to number their paragraphs in their respective petitions, contrary to the directive of Section 2, Rule 7 of the Revised Rules of Court. Santa Maria et al., Algamar Latif, Hindi Abendan of Center for Youth Participation and Development Initiatives et al., Monsod et al., and Lawrence A. Yerbo. The petitions are riddled with procedural infirmities that warrant no less than dismissal. Number 5, petitioners have no locus standi to file the subject petitions. Not only the petitions suffer from formal defects, but these also fail to establish requisites for judicial review. Again, 37 petitions were filed assailing constitutionality of the Anti-Terrorism Act. In these consolidated cases, petitioners invoke their diverse capacities, hoping to justify and establish their legal standing that will merit the consideration of this honorable court. The principle of locus standi has long been settled. It calls for more than just a generalized grievance. It must be a personal and substantial interest whereby a person will incur direct injury due to the governmental act assailed. It should be material, not merely incidental. There should be a present substantial interest and not a mere expectancy or a future contingent, subordinate, or consequential interest. Majority of the petitioners invoked and repeated harp on the doctrine of transcendental importance to justify their obvious lack of direct and personal interest in their cases. Moreover, they violated outright the hierarchy of courts. In the absence of exact definition, jurisprudence provides the following as determinants of the application of the doctrine. Number 1, the character of the funds and other assets involved in the case. Number 2, the presence of a clear case of disregard to a constitutional and statutory prohibition by the public respondent agency or instrumentality of the government. And number 3, the lack of any other party with a more direct and specific interest in raising the questions being raised. There are now exists parties with more direct and specific interest in the very issues being raised before the Supreme Court than herein petitioners. To reiterate, criminal cases have been filed already against two ATAs at the Regional Trial Court of Olongapo City for violation of the Anti-Terrorism Act. Petitioners do not also allege any link to the two ATAs. This automatically divests petitioners the right to invoke the doctrine of transcendental importance, on which their whole theory on locus standi depends on. Unlike the ATAs who lost their liberty, the petitioners did not suffer any direct or indirect injury that will vest them with locus standi. Number 6, there exists no actual controversy in this case. Apart from the petitioner's lack of standing, there is also a complete absence of any actual justiciable controversy to be settled in this honorable court. Justice Leonan pointed out this fatal defect of the petitioners during the interpellation. An actual case of controversy is one which involves a conflict of legal rights, an assertion of opposite legal claims susceptible of judicial resolution as distinguished from a hypothetical or abstract difference or dispute. Courts will decline to pass upon constitutional issues through advisory opinions, bereft as they are of authority to resolve hypothetical or moot questions. Similarly, petitioners' obscure allegations of future and contingent surveillance and red tagging, among others, are not credible threats of prosecution that would make the petitions as actual justiciable cases or controversies. Clearly, the present petitions grossly failed to show the existence of an actual case or controversy over which this honorable court may exercise its judicial power. Number 7, direct resort to this honorable court is unjustified. Another fatal flaw in the direct resort to this honorable court to challenge the Anti-Terrorism Act is the failure of petitioners to follow the doctrine of hierarchy of courts. Let me quote Amicus Curiae Justice Hardilesa, speaking for this court in Gius Samar versus DOTC, and I quote, "The doctrine of hierarchy of courts dictates that direct recourse to this court is allowed only to resolve questions of law, notwithstanding the invocation of paramount or transcendental importance of the action," unquote. This doctrine is not to be taken lightly. A petitioner has no unfettered discretion to compel this honorable court to jump over the hierarchy of courts. Therefore, the petitions must be dismissed. Number 8, this honorable court is not a trier of facts. Majority of the petitioners cited factual allegations relating to supposed red tagging, the truth or falsity of which are clearly doubtful. There is a question of fact when the doubt arises as to the truth or falsity of the alleged facts. It is well settled that this honorable court is not, and I repeat, not a trier of facts as provided for in Section 2, Rule 3 of this court's internal rules. We quote a portion from Gius Samar case penned by Amicus Curiae Justice Hardilesa, and I quote, "This court, however, is not a trier of fact. We cannot resolve these factual issues at the first instance," unquote. For raising questions of fact, the foregoing petitions should be dismissed. Number 9, A facial challenge against the ATA is improper. We shall now controvert pertinent issues raised in the advisory to assuage the fears of the public from those who demonize the Anti-Terrorism Act despite its noble intent to protect the public. A caveat on the petitioner's reliance of facial challenge. In Humambil versus Cafe, the policy of the courts is to avoid ruling on a constitutional question and to presume that the acts of the political departments are valid in the absence of a clear and unmistakable showing to the contrary. In Romualdez versus Comelec, this court ruled that under no case may penal statutes be subjected to a facial challenge and should not be declared unconstitutional for overbreadth and vagueness. This principle has been affirmed as good law by this court as recently as 2019 in Madrilejos versus Gatdula. Amicus Curiae Justice Hardelesa quoted Romualdez versus Comelec that facial challenge against a penal statute is at best amorphous and speculative. It would essentially force the court to consider third parties who are not before it. As emphasized by Justice Mario Lopez, never before anywhere has a facial challenge been mounted against a penal statute defining and punishing crimes against national security. The rule must stand. Constitutionality of the Anti-Terrorism Act may only be assailed in actual criminal trial. Number 10, the ATA is a valid exercise of the police power of the state. Several petitioners question the constitutionality of the ATA on the ground that the law does not satisfy the tests of a valid exercise of police power. They are wrong. In Zabal versus Duterte, this honorable court described police power as the inherent and plenary power of the state, which enables it to prohibit all things hurtful to the comfort, safety, and welfare of the society. The strict scrutiny test requires that a law, number one, is necessary to achieve a compelling state interest. And number two, it is the least restrictive means to protect such interest. On the first requirement, no less than the Constitution declared as principle the prime duty of the government to serve and protect the people and to secure the sovereignty of the state and the integrity of its national territory. The second requirement of strict scrutiny, the adoption of least restrictive means, has always been fully complied with. The Anti-Terrorism Act adopts narrowly drawn mechanisms to avoid conflict with constitutional rights. Since the Anti-Terrorism Act is a penal statute, the Congress meticulously puts safeguards in the Anti-Terrorism Act to avoid abuses. Among these are the prohibition against torture or coercion in investigation and interrogation, and the upholding of the constitutional rights of persons under custodial investigation. Moreover, the Anti-Terrorism Act assures that its implementers will not abuse their authority. ATA is replete with provisions that penalize abuses in its implementation. There are checks and balances in the law to make sure that grave abuse by the implementers will be penalized with imprisonment to deter exploitation of the law. Therefore, contrary to petitioners' argument, there is no undue restraint allowed by the Anti-Terrorism Act. It is crystal clear that the Anti-Terrorism Act is brimming with strong safeguards that will effectively prevent abuses in its implementation and protect persons under the custody of the law. The Anti-Terrorism Act is a result of studies and specific findings of the legislature on the serious threat of terrorism, domestic and international alike. The state cannot turn a blind eye on the practical realities brought by terrorism. On this note, the wisdom of the legislative decision to crush terrorism while giving justice to any person in interest should be abided. The honorable interest has upheld time and again. Individual liberties must give way to the compelling state interest. As eloquently stated by Justice Amy Lazaro Javier, the state has the right to protect itself. In this case, the far more overriding demands and requirements of the greater number is to live safely in peace instead of being perpetually paralyzed as a victim of terrorism. The full enjoyment of basic rights can only be achieved if there is freedom from fear. The Anti-Terrorism Act satisfies the test as to whether the law is a valid exercise of police power. Number 11, terrorism is a criminal conduct with specific intent. The definition of terrorism under Section 4 of the Anti-Terrorism Act is complete. It is neither vague nor impermissibly overbroad. Under Section 4 of the Anti-Terrorism Act, the crime of terrorism consists of two elements: the actus reus, or the overt act, and the mens rea, or the criminal intent. It identifies 5 distinct acts, 3 of which are intent-specific, which in order to qualify as terrorism must be intended to accomplish any of the following purposes: to intimidate general public and segment thereof, to seriously destabilize or destroy fundamental structures of the country, to create a public emergency, and seriously undermine public safety, as repeatedly echoed by Chief Justice Alexander Hesmundo and Justice Mario Lopez. To repeat, the law is clear. It is conduct coupled with specific interest which comprises the crime of terrorism. Number 12, the ATA maintains probable cause in warrantless arrest. There is nothing in the anti-terrorism that eradicates probable cause as the threshold in conducting valid warrantless arrest. It remains to be an ironclad rule. Moreover, the phrases suspected of and charged with are used in the law as antitheses of each other. This means that the phrase suspected of simply refers to someone who has not yet been charged with before a court for violation of the Anti-Terrorism Act. In other words, a suspect in ordinary parlance. The use of the word suspected in Section 29 does not wipe out the threshold of probable cause in warrantless arrest under the rules. Number 13, the ATA ensures lawful data acquisition and handling. Neither does the Anti-Terrorism Act violate the citizen's right to privacy. The law contains sufficient safeguards to ensure that data are lawfully acquired and properly handled. Section 18 requires that the written surveillance order to be granted by the Court of Appeals should contain 1. Identity of the person to be surveilled, 2. Identity of the law enforcement agent or military personnel judicially authorized to undertake surveillance activities, number 3, the offense or offenses committed or being committed or sought to be prevented, number 4, the length of time within which the authority shall be used or carried out. This accountability-driven system of checks and balances is noticeably absent in other countries' anti-terrorist legislation. In Canada, for one, only the ministerial authority issued by the Minister of National Defense is needed to greenlight any interception of private communications. Meanwhile, India's Information Technology Amendment Act of 2008 gives its government the sweeping power to tap all communications without any court order or warrant. Number 14, the ATA regulates conduct, not speech. Contrary to petitioner submissions, sections 4, 5, 6, 7, 8, and 9 of the Anti-Terrorism Act do not violate the freedom of speech, expression, and of the press. The Anti-Terrorism Act was enacted to protect individuals from terroristic attacks, to ensure respect for the right to life and the right to security of each citizen. The state is compelled to regulate the conduct of its citizens as they exercise their rights, and the same is absolutely different to the postulated suppression of free speech. A clear distinction between the regulation of conduct vis-a-vis regulation of speech has been explicitly defined in Southern Hemisphere versus ATC. Almost every commission of crime entails some nuancing of words on the different part of the offender. Thus, utterances not elemental but inevitably incidental to the doing of the criminal act does not alter the intent of the law to punish socially harmful conduct, nor the essence of the whole act is conduct and not speech. When a person speaks directed to another person or group of persons is of a quality that is likely to engender violent conduct, that communication, though verbal, is not speech as a part of the dialogue. Such speech is more akin to, in nature, to conduct, because it is more likely to provoke conduct than dialogue. Therefore, it may be restricted as fighting words without regard to any message being communicated. The anti-terrorism penalizes terrorism whether committed through acts or through written or verbal communications. Specifically, terrorism as defined in Section 4 is clear and unambiguous. So are Sections 5, 6, 7, 8, and 9. They penalize conduct and fraudulent advocacy, inviting imminent lawless action and danger to national security with the apparent intent to incite people to support or commit terrorism. Notably, the prohibitions under this section fall within the same class of crimes already punished in the revised penal code as shown in this slide. All told, Sections 4, 5, 6, 7, 8, and 9 of the Anti-Terrorism Act do not violate the freedom of speech, expression, and of the press. When a speaker's words do not contribute to dialogue or the expression of ideas, but are instead intended to provoke harmful conduct, they have no value as instrument of speech. Number 15, the ATA does not contravene the right to speedy trial and disposition of cases. Section 29 of the ATA does not violate a person's right to speedy trial and speedy disposition of cases. The petitioner should know that the right to speedy trial only attaches at the start of the trial and not prior thereto. This right, therefore, does not find application during the period of detention under Section 29 of the Act. Petitioners should be reminded that the right to speedy disposition of cases is a relative and flexible concept, and in no way can a mathematical reckoning of the time be considered as an inordinate delay. The peculiarity surrounding the crime of terrorism clearly justifies this period of detention. Number 16, the ATA's power are purely executive in nature. Petitioner should know that the Anti-Terrorist Council's written authority mentions Section 29 of the Anti-Terrorism Act is not a judicial warrant of arrest. Section 29 honors the inflexible truth that the issuance of a warrant of arrest remains to be an exclusive judicial process. Section 45 of the law states, nothing herein shall be interpreted to empower the ATC to exercise any judicial or quasi-judicial power of authority. Section 25 on designation is essentially an identification of a person or a group as being involved in terrorist acts. Unfortunately, petitioners misconstrue designation as a sweeping grant of prosecutorial, legislative, and judicial powers to the ATC. Nothing in the ATA empowers the ATC to file information or issue an arrest warrant. Rather, designation is an administrative and executive function of the Anti-Terrorism Council to facilitate the imposition of financial sanctions on terrorists. Designation plays a crucial role in the issuance of a freeze order by the Anti-Money Laundering Council to prevent terrorists from accessing funds. The only participation of the ATC in the freezing of assets is sending a request to the Anti-Money Laundering Council, which is not an automatic deprivation of the designee's property. Next, designation does not inflict punishment ex post facto based on the adoption of the United Nations Security Council consolidated list and other requests for designation. Section 55 of the Anti-Terrorism Act explicitly provides a prospective application. Therefore, the anti-terrorism only imposes a penalty of acts or omissions committed after its effectivity. Petitioners are mistaken in assailing the adoption of the consolidated list, which includes all individuals and entities from across the globe that are involved in terrorism and are subject to measures imposed by the Security Council. Reference to consolidated list complies with the requirements of a valid delegation of a legislative power of the ATC. First, the ATA is complete. Second, the ATA defines legislative policy, which is to protect life, liberty, and property from terrorism. The ATC does not have the sole arbitrary discretion to determine who the terrorists are and what acts constitutes terrorism. Why? Because it is guided by the standard of probable cause, reasonable ground of suspicion supported by circumstances warranting a cautious person to believe that the proposed designee meets the requirements for designation. This is further limited by explicit reference to offenses found in sections 4 to 12 of the Anti-Terrorism Act. Hence, the ATC cannot designate on mere suspicion, contrary to petitioners' unfounded fears. Number 17, the government is not the enemy. Recently in Oriental Mindoro, the CPP-NPA's plans to terrorize the citizenry, harass local law enforcement, and set critical infrastructure ablaze in time for its 52nd anniversary were foiled. Let us credit the efforts of the AFP's 4th Battalion, Scorpion Battalion. Our brave men and women in uniform were able to recover high-powered firearms, explosives, and ammunition, as well as documents outlining the NPA's dastardly plans. It is no secret that the CPA-NPA always resort to acts of terror in its bid to seize control of the government through armed struggle. No price too steep, no institution too sacred. Even going so far as to recruit children in their misguided cause. You can see them in the picture. On March 30, 2021, less than a month ago, PNP contingent raided a CPP-NPA armory at Santa Rosa, Laguna. Like in Mindoro, the police officers too found a cache of high-powered firearms and explosives, which included improvised anti-personnel and claymore mines. Likewise discovered in the armory were subversive documents, streamers, campaign paraphernalia of Congressman Colmenares, Bayan Muna, and Gabriela, and training materials on advanced revolutionary warfare. More recently still, on April 16, 2021, the 110nd Brigade, Infantry Brigade, encountered members of the Abu Sayyaf Group. The Abu Sayyaf Group engaged the Philippine Army in a firefight in Patikul, Sulu. Our armed forces prevailed and crippled the reign of terror by trained bomb maker Abu Katab Jundula, Abu Sayyaf fighter alias Akram, an Egyptian volunteer suicide bomber alias Yusuf, who is the son of Reda Muhammad Mahmoud, a suicide bomber in an army base in Sulu in 2019. Katab and Yusuf are under Muzimar Mundi Sawadjaan, who is behind the twin suicide bombings in Holo in August 2020, as well as the Holo Cathedral bombing in January 2019. Your Honors, petitioners have never spoken out against the recent atrocities committed by terrorists against our people. If they have never taken a stand on these acts, and if silent is complicity, there can be only one inescapable conclusion. Like any other law that has implications on individual rights, the Anti-Terrorism Act has been unfairly stigmatized as a mere legal ruse to quell oppositions against the current administration. This is a monstrous lie. The Anti-Terrorism Act is not an instrument of oppression. Neither is it a tool to suppress vibrance of our democracy. No, it is an embodiment of the state's policy to protect life, liberty, and property from terrorism. A commitment to peace in our day and future of our children. In the words of our President Rodrigo Roa Duterte, and I quote him, "For the law-abiding citizens of this country, I am addressing you with all sincerity. Huwag ho kayong matakot kung hindi ka terorista." Thank you, Your Honors. Senator, Your Honors,
Thank you, Mr. Solicitor General.
for purposes of interpellation, Your Honors, we have filed a manifestation and motion last January 28, 2021, in compliance with the Honorable Court's advisory dated January 5, 2021. We have divided our chores, Your Honors. The Solicitor General handled the opening statement, and two of his Assistant Solicitor Generals, namely Reyna Godon and Marisa de la Cruz Galandines, will answer questions on the opening statement and any questions on the Bill of Rights and other provisions of the Constitution, respectively. Thank you, Your Honors.